Japan's plan to set up a practicable and reasonable system of peace was aimed at rendering fruitful the results of this war. In all these points, the war fought by Japan had nothing in common with that of Germany. The Japanese leaders neither ordered nor knowingly connived at the commission of atrocious acts. Inhuman deeds were just what they did their best to prevent. We are convinced that all these accused, including Tojo, must be found not guilty by the tribunal. We respectfully and earnestly submit that a trial by civilization based solely upon law and justice, and rising far above the hatred and prejudices which the war has entailed, will show us the right way to lasting world peace.
Mr. Levin. Mr. President, I would like to present Dr. Cassano, who will continue the defense summation on personal responsibility.
いたします。同弁護人は個人責任論を継続するはずであります。
As I understand it, the Togo and your major summations are not quite ready, and this, I believe, will fill in the gap if it's agreeable to the tribunal.
私の聞くところによりますと、統合及び梅津の個人弁論がまだ十分準備ができてないそうでありますから、今ここに個人責任論をやれば、その間の間隙を埋めることができると思います。
裁判長並びに裁判官各位。
Mr. President and members of the tribunal, the object of this summation is to analyze the alleged criminal responsibility of all the defendants from the point of view of modern criminal law. The chief prosecutor said in his opening statement as follows: since the usual definition of murder in civilized countries is the intentional killing of a human being without legal justification, we should perhaps see what constitutes legal justification. This justification is usually limited to the defense of one's person or property, or perhaps, in the case of an execution, that he was merely carrying out the order of a properly constituted court. The question of legal justification is, of course, important, but such can be understood only when the question of intention is taken into consideration at the same time. Unfortunately, however, the chief prosecutor left the latter entirely out of his discourse, as if the criminality of the defendant's intention is taken for granted. 52. If these defendants must at any cost be adjudged directly under international law for acts done in their official capacities, although there exists no such precedent, it is my sincere wish that the tribunal would take into consideration the general principles of law recognized by civilized nations, in particular those elementary principles of criminal law which are submitted in the above. Professor Holsworth remarks that primitive man is like the civilized state, and compares the criminal law of ancient times with the present state of international law. I am convinced, however, that the international law which would be administered by this honorable tribunal would be in no wise contrary to the sense of law developed by criminal legislations of modern civilized states.
We will recess for 15 minutes.
後ほど正誤表を配布いたすつもりであります。
General, 1. There are several circumstances which are calculated to require the summing up of the case of Tomo Shingenori at greater length than would ordinarily accord with the desires of court or of counsel. One of these circumstances, one quite extraordinary, and in this trial unique, raises questions so basic that it must be mentioned at the outset. The defendant Tomo is charged by 44 of the 55 counts of the indictment. 2 of these, the prosecution, after long shrinking from acknowledgement of the typographical error, which in them had put Togo for Tojo, in January 1947 dismissed as to this defendant. As to 2 others, the charges will not be pressed by the prosecution, which may be supposed to amount to a nolle prosequi. Of the remainder, 25 relate in whole or in part to the activities of Mr. Tojo prior to his becoming foreign minister in October 1941. It is from this condition that arise the basic questions mentioned above, which perplex us to know what case we have to meet. 2. For after the Tojo defense was opened, the chief prosecutor arose to state to the tribunal a limitation of the charges to be urged against this defendant, in that the prosecution, subject to the reservation to be mentioned presently, seeks conviction of the accused Tojo for his actions beginning with his assumption of duties in the Tojo cabinet. This limitation, which seems clear enough as it relates to the substantive charges, was subsequently acknowledged by the chief prosecutor to imply also that the prosecution did not charge the defendant Tojo with having joined in any conspiracy before he joined the Tojo cabinet, which was in October 1941. These were, of course, not idle words, spoken without consideration of their effect by the chief prosecutor, not an expression of opinion or of an inchoate future intention. They constituted the solemn, official statement of the prosecution of its position in regard to the cause, its commitment to the case which it considered it possible and proper to submit to the tribunal against this defendant. That commitment being stated to have been made for the purpose of assisting the tribunal in carrying out Article 12, Paragraph A of the Charter, that part of it as follows: to confine the trial strictly to an expeditious hearing of the issues raised by the charges, it should presumptively have been possible to rely on it for definition of the issues which the prosecution, who have the right and the power to frame them, would contend to have been made. The defense might reasonably have expected that the case which it would be called upon to meet would be a case limited to investigation of the criminality of Mr. Tojo's actions from the time of his becoming foreign minister in October 1941.